Hello, everyone. How are you? Hope you're all well. Yesterday, I uploaded my video on the New York Times motion for summary judgment against Wayfarer in their New York State lawsuit, where they are requesting an award of their attorney's fees for, because due to the fact that Wayfarer included them in a lawsuit, which was then subsequently dismissed with prejudice. And we talked through all of that. I had a lot of comments, great comments actually, some really great points, which as a kind of individual, I can look at and I feel the same sense of injustice. But I wanted to do something where we actually look at it from the legal standpoint. So I've highlighted this. There's 2 points I'm going to go over. This is the first one. Now, many comments, rightly so, said, well, this statement by the New York Times, which says, to date, the Wayfarer plaintiffs have not appealed the federal court's decision. They've said that it's misleading. Now, I do agree that it could be read that way. It does. There is, I guess, a way you can look at it where it almost does imply that the New York Times are kind of saying to the judge, well, they haven't appealed, so, give us the fees. I did point out in my video at the time, I was like, well, yeah, technically they haven't appealed. But that's because, as it stands, Lyman has issued a court order. I'm just finding the court order. Here it is. So Lyman issued an order on the 31st of October last year, where he basically said this. Do I read it? Right. Only Blake. Oh, right. I'll read from the start of this paragraph. Actually, only defendant Blake Lively responded to the order to show cause. In her letter, which we can look at in a minute as well, if I can find it, Lively asserts that the court should enter final judgment while also treating her pending motions for fees as timely motions under Federal Rule of Civil Procedure 59. And then he goes on to say, the effect of doing so would be that the time to file an appeal in this matter would run for all parties from the entry of the order disposing of the motions for fees. Now, this is Lively's request for damages under Section 47.1, her treble damages claim. So the time to file an appeal in this matter would run for all parties from the entry of the order disposing of the motions for fees rather than from the entry of final judgment. Although arriving at this conclusion requires a somewhat circuitous route through the federal rules, the court agrees that Lively's unopposed approach is appropriate under the circumstances. So normally, judgment would be entered. And then at that point, Rule A1A would kick in. So let's go and look at that. So as you can see at the top, right, we're on Rule 4. This is of appellate procedure. A, appeal in civil case. 1, time for filing a notice of appeal. A, in a civil case, except as provided in Rules 4A1, 4A1B, and 4A4 and 4C. And 4A1B applies to kind of government officials, etc., United States agencies and all that. That's not the case here. So we are looking at Rule 4A1A. In a civil case, except for those rules I've just mentioned, the notice of appeal required by Rule 3 must be filed with the district clerk within 30 days after entry of the judgment or order appealed from. So the reason that order from Lyman came about was because what would have happened is if Lyman had entered judgment which he did do, but let's just, right, but for argument's sake, Lyman entered judgment without the order saying, but we're going to stay, we're going to stop the clock. Then Wayfarer would have had 30 days from the order entering judgment. Okay? So they would have had 30 days from that order dated the 31st of October to file notice of appeal. What Lively's motion did, what she basically said was, look, for efficiency, and I don't overly disagree with her. I hate to say it, but I don't overly disagree with her. But for the sake of efficiency, right? If you deny my request for treble damages, I'm going to appeal. So why don't you, hold off, like enter judgment, but hold off starting the clock until you have ruled on my request for my Section 47.1 remedies, because then we can all appeal together. And Judge Lyman, because it was unopposed, actually, Wayfarer didn't oppose it. New York Times didn't oppose it. Wayfarer actually said nothing at all about, in response to New York Times even requesting final judgment. So I think they are either not going to appeal at all, or they are ready for the clock to start an appeal. But anyway, because Lively made that request and it was unopposed, and Lyman kind of saw the practicalities around that. So that is what has happened there. Now, does that mean that the New York Times misled the New York State Court? No. If we're looking at it, taking the document on its face value, no, it doesn't. So their wording is actually, to date, the Wayfarer plaintiffs have not appealed the court's decision. I'm just trying to get back to this. As you can see, to date, the Wayfarer plaintiffs have not appealed the federal court's decision. So for that statement to have been misleading, the Times would have to have known an appeal was filed and tell the New York court that no appeal existed. But Wayfarer haven't actually, to date, filed a notice of appeal. So factually, the New York Times statement is correct. I did say, from a kind of, like I said, that I said myself in my own video, that's, a little misleading. I think, like, that's me being kind of, well, with the firm belief that, and I think I said this in my video, I'm expecting the response from Wayfarer to this motion for summary judgment to include the fact that, oh, hold on a minute, Judge Lyman, has told me to, I can't file an appeal just yet. I have to wait. And I'm expecting them to confirm that they either do intend to appeal the dismissal of their lawsuit or they don't. So that's what I'm expecting to happen. However, New York Times, like it or not, technically their statement is true. Wayfarer is not allowed to appeal just yet. The window has been frozen because of that court order from Lyman. And they have not filed any notice of appeal. So to say that they have not appealed is not misleading in the literal sense, if that makes sense. Okay, was there something else? Yes. Right. So this comment, this statement here, to discourage slap suits, which chilled the free exchange of ideas. New York's anti-SLAPP statute requires that courts award attorney's fees to a party if it can show, one, that it was sued for speaking on a matter of public interest. I had a brilliant comment, actually, again, which, I can see why I would, as a person, agree with it. But I can also see from a legal perspective why it's not that straightforward. So someone actually pointed out the CRD complaint. The CRD complaint is confidential. It is not in the public record. And they rightly pointed out, well, the New York Times has been working on this since at least October. We know that. The dismissal from Lyman as well does actually reference, I'm just getting to that. So this is the court order, the June 9th court order, which dismissed Wayfarer's entire complaint against Lively, Reynolds, Sloan, Vision, and the New York Times. And Lyman, if I make this a little bit bigger, Lyman has said this. He's acknowledged this. There was a powerful inference that the Times had access to the CRD complaint well before that date being the December 20th, which was the day it was filed. The article and CRD complaint are both purportedly based on thousands of pages of text messages and emails that Lively obtained through a subpoena. And I will come back to the subpoena, which the article states were reviewed by the New York Times. URLs for images, PDFs, and videos associated with the article contain dates December 12th and December 10th. So I think it was Gucci Pooch found the metadata for December 12th, and Melanie King found the December 10th, I believe. I know, it might have been Gucci Pooch and December 16th. It's Gucci Pooch found December 16th. I know that. I know Melanie King found another one. And then I think Gucci Pooch found another date. I can't remember who. It's been a while. Okay. The article draws heavily from Lively CRD complaint. It would have taken time to review that complaint and its attachments. In addition, source code for a portion of the article contains the date October 31st, 2024, and that's the date I found. And because the Times had access to the CRD complaint before it was filed and while it was still confidential, there is also a powerful inference that it was provided by Lively or by someone on her team. Lively obviously had access to the CRD complaint before it was filed. It only makes sense that the CRD complaint was given to the Times by Lively or someone acting on her behalf. So Lyman does actually address the fact that in order for the New York Times to have gone through the CRD complaint and the thousands of pages of text messages and emails that it admits it went through, and also for them to have, I believe the video was with Megan Twohey was filmed in advance of the release of the article. And then from all of that, then to have gone on and written a 4,000 word article in less than 24 hours. Because Megan Twohey had contacted Wayfarer on the 20th as well, the day the CRD was filed. She'd emailed the Wayfarer parties the day it was filed, and which was obviously the day before the article itself was released to the world. And she'd asked for their comment on all of this. So it's abundantly clear that the New York Times had access to all of this well in advance. So one of the other things that Lyman said in this report, because he was looking at all of this through California law. I'll just highlight this bit. Okay. So the Wayfarer Party's main response is that the privilege does not apply because at the time Lively provided the CRD complaint to the Times, it had not yet been filed in an official proceeding. And that is almost certainly true. However, under California law, which is the law he was applying to Wayfarer's complaint, because that's what they asked for. However, under California law, a party need not wait until a legal document is formally filed before providing it to members of the press. The fair report privilege extends to advance communication to a public journal of a complaint so long as the party intends in good faith to file it in a public official proceeding. Now, I won't get into the nuance of whether Lively filed the CRD complaint in good faith. I personally, I don't think so. No. If I had to, if someone said to me, "Nan, do you think she did it in good faith?" No, I do not. But I don't know that for sure. This is just my opinion based on everything else I've seen and, my direct interaction with her attorneys. Lyman does not know this. He doesn't. And he's kind of got a difficult job of trying to balance this lawsuit, where on the one side you've got a female who's made a complaint alleging sexual harassment in the workplace, and then on the other side you've got the male. Let's just go with Lively's wording here, because it's still up for for just like it's still up to be decided really on what she is. Is she an employee or is she a subcontractor? Again, I have a very strong opinion on that. I do not believe she's an employee, but that has not been formally decided, and it is a fact that's in dispute. But we'll go with Lively's allegations. She says she's an employee, so on the other side, you've got the male employers saying, "No, we didn't. That's not true." And he has got to be sensitive towards this, and it's kind of got to. I know what I'm trying to say, but do you know what I mean? He's like got to handle this with delicacy and get the decision right. So I mean, he has been overly given to Lively in his decisions. We all know that. I think some of it has crossed the line a bit, but I can also see why he is trying to be seen to be fair and to try to protect his decisions from being appealed by Lively. So the net point we're at now is that under California law, which this decision was made by Lyman on, the complaint does not have to have been filed. She just has to have had the intention to file it in good faith. Okay? But what I did go away and have a look at is would that apply in under New York law? If that decision had been all decided on New York law, would that remain the same? I'm just getting to the page. Okay, so the fair report privilege falls under Section 74. Okay, New York courts, New York's fair report privilege can apply to reporting on legal documents before they are filed, but only in very specific circumstances. So the key is whether the document is already part of an official proceeding or has been communicated to an official body, even if the public filing hasn't happened yet. Okay, so New York courts focus on the nature of the proceeding, not the moment of public filing, and the privilege applies when the document has been submitted to, lodged with, or officially communicated to a government agency, even if it has not appeared on, something like a public docket. So, Blake Lively complaint had been filed with the California Civil Rights Department. And although that technically that's not a court filing, but it is a government. The CRD is a government agency, and a complaint submitted to it is an official proceeding for the purposes of fair report. New York's fair report privilege protects a fair and true report of any judicial, legislative, or other proceeding. And courts interpret official proceeding broadly. The privilege applies when the proceeding has begun, or the agency has received a document, or the document is part of an official investigation. What it does not require is public docketing, a stamped filing date, or a court case number. Now, there are a few cases that kind of set precedents in this kind of industry. You've got, firstly, freeze-right refrigeration, which was an appeal in 1984. The privilege applied to reports about a government investigation before any charges were filed. You also have the Holy Spirit Association, which was actually a case against the New York Times from 1977. In that case, the Court of Appeals held that the privilege applies even when the underlying documents are not public, as long as they relate to an official proceeding. And then you've got, I'm probably going to butcher these names, but Cholowski against Civiletti, which is, again, another appeal in 2010. In that, the privilege applies to reports on complaints filed with administrative agencies, even if the agency has not yet taken action. And those cases, kind of collectively make it clear that public filing is not the trigger. The trigger is submission to an official body. So, what is the rule? If the document has been submitted to a government agency, privilege applies, even if it's not yet public. If the document is part of an official investigation, privilege applies. Where it doesn't apply is if the document is purely private, unfiled, and not yet submitted, privilege does not apply. So when we apply this to the Times, like everyone says, well, they were working on the article before she filed the document. Absolutely, 100% agree. But what happened with the New York Times was they state this in their article, the Times relied on Blake Lively's CRD complaint and communications that were incorporated into that complaint. Now, because the CRD is a government body, the complaint is an official proceeding in the moment it is submitted. So, under New York law, yes, the fair report privilege applies, even though the CRD complaint was not a court filing. But the CRD was a confidential document. Yes, it was. Fair report privilege can still apply even if the CRD complaint is confidential. Let's have a look. So, New York's fair report privilege does not require the underlying document to be public. That is the most important point. New York's Court of Appeals, the highest court in the state, has held repeatedly that the privilege applies even when the underlying documents are not public, sealed, or confidential, so long as they relate to an official proceeding. And again, the leading case in that is the Holy Spirit Association against New York Times, where the Court of Appeals held that the privilege applied to reports based on non-public government documents. That would include the CRD. And the logic is simple. The privilege protects the act of reporting on official proceedings, not the public availability of the documents. So confidentiality does not defeat the privilege. A CRD complaint is an official proceeding the moment it's submitted. California Rights Department is a government agency. A complaint submitted to it triggers a statutory investigative process, a mandatory agency review, and potential enforcement actions. So, under New York law, that is unquestionably an official proceeding for the purposes of Civil Rights Law, Section 74. It does not matter that the complaint was confidential, or that it was not yet public, or that it was not yet acted upon, or that it was not yet, or that it was not filed with a court. The privilege attaches at the moment the complaint is lodged with the agency. And as I've just said, those three cases all kind of solidify that view. Confidentiality rules bind the agency and not the press. Now, obviously, that is even more so where Blake Lively, who is the complainant, has given over a copy of her complaint to the CRD. She has chosen to waive that confidentiality. But a confidentiality statute, like the CRD's, restricts what the agency may disclose, but it does not restrict what a journalist may report if they lawfully obtain the document. Now, so the Times relied on Blake Lively's CRD complaint and communications that were incorporated into that complaint. So even if the CRD complaint was confidential, it was submitted to a government agency. It technically initiated an official proceeding. And yes, she waived the right to that and just wanted the right to sue letter. But that is still, do you know what I mean? That's an official act, the issuance of the right to sue letter. A New York law protects reporting on such proceedings. Now, to circle back round again, but the New York Times worked on the article for months before the CRD was filed. And this is the only genuinely tricky part of the fair report analysis in this case. And Lyman did actually address it head on in his dismissal. Yes, the Times worked on the article for months before the CRD complaint existed. That's normal investigative journalism, and it does not affect the fair report privilege. Why? Well, because the privilege does not protect the news gathering process. It protects the published report if and only if the published report is based on an official proceeding. So the question is not when did the Times start reporting? It's when the Times published the article, was it reporting on an official proceeding? And the answer is yes, because by publication day, Lively had filed her CRD complaint. The Times had obtained it, the article explicitly cited it, and the complaint was already before a government agency. And that is all New York law requires. The privilege attaches at publication, not at the start of reporting. And this is kind of the key doctrinal point. Under New York civil rights law, Section 74, the privilege applies if the published article is a fair and true report of an official proceeding that existed at the time of publication. It's important to kind of point out, it does not matter how long the journalist worked on the story, whether earlier drafts relied on non-privileged material, whether the complaint was confidential, whether the complaint was filed shortly before publication. It also does not matter whether the information in the CRD is false. For the purposes of just protecting the New York Times, even if everything in Lively's CRD complaint turns out to be false, which I anticipate it, largely will, in my opinion, that does not matter. The New York Times would still be protected as long as they accurately reported on what the CRD said. So the privilege is evaluated as of the moment the article is published. And at the moment the article was published, the CRD complaint was, well, it was in existence. It was submitted. and therefore it was official. Let's see. Yeah, so again, Lyman addressed this argument himself, and he did reject it for the same reasons. Wayfarer argued that the Times had been reporting long before the CID complaint existed, so the privilege shouldn't apply. Lyman rejected that outright and held that the article, as published, was based on the CID complaint. The complaint was an official proceeding. The privilege therefore applied. The timing of the reporting process was irrelevant. This is why the defamation claim was dismissed with prejudice in regards to the New York Times. Okay. So that's where we are there. Now, I wanted to go back to, there was something I wanted to go back to. I'm just, bear with me, I'm just scrolling, but I'm sure people don't want to see me scrolling up pages and pages. I've had some people say it gives me a headache, which is fair. It gives me a headache too. So I'll get to the point and then I'll switch the screen and show you what I'm looking at. But I did say I would come back to this. All right, I've got it now. Okay, so we're back on, this is the order to dismiss Wayfarer's lawsuit. This bit, the article states, I felt like Lyman actually gave some weight to the fact that, you know, the article made the point of saying that Lively obtained through a subpoena. Now, again, you know, if the New York Times had seen the actual subpoena that had been used to get the documents, I would have an issue with that. I would have a big issue with that. And I am going to pull up the reason and go through it with you. Okay. So this is a subpoena that was used to obtain all of the, the text message and everything that was, according to the New York Times, obtained through a subpoena. Now, the New York Times, I would expect to be the kind of publication that would ask the questions, where did you get all these text messages from? To fact check that it was lawfully obtained before reporting on them. And if this is the subpoena that they were presented to, as well, yes, here's a copy of the subpoena. If this is what they were given, I would be expecting them to ask questions. Because this is the Van Zandt subpoena. Plaintiff is Van Zandt against does 1 to 10 inclusive. And we'll go through and so this is Schedule C, the documents that are actually requested. All documents and communications concerning Lively, Reynolds, their families, and or the Lively Reynolds companies. All documents, communications concerning instances of actual or apparent inappropriate conduct relating to sexual harassment or retaliation in connection with the production, development, marketing, publicity, or public relations of, for, or related to the film. All documents and communications concerning allegations of actual apparent conduct, relating to sexual harassment or retaliation in connection with production, blah, 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 of the film. So that's concerning instances, concerning allegations, just to make sure that no one thinks I've read that twice. All documents and communications concerning investigations or other responses to allegations. And then it continues the same. All All documents, communications concerning the marketing and publicity efforts or press related to the film, related to retaliatory efforts to disparage Lively, Reynolds and or the Lively Reynolds companies for any reason, including for reporting inappropriate conduct relating to sexual harassment during the production of the film and individuals involved in such efforts. Or in anticipation of public disclosure of such conduct. All documents and communications concerning with respect to each of the categories 1 to 5, retaliatory actions taken in anticipation of the Lively, Reynolds, their families, and or the Lively, Reynolds companies making disclosures or bringing claims regarding actual or apparent inappropriate conduct relating to sexual harassment in an effort to discredit, undermine credibility, or otherwise harm Lively, Reynolds, their families, or the Lively, Reynolds companies. Now, so those particular pages, right? This all makes sense. Okay, this sounds like, yeah, okay, I can see why, I can see the relation there because it specifies Lively, the film, her husband, the businesses, etc. Also specifies sexual harassment, also specifies retaliation, etc., etc. But if I was New York Times, who are very experienced at this, let's be clear about this, right? They have reported on thousands and thousands of lawsuits. I would be asking, who the fuck is Van Zandt? And given that the New York Times was specifically referencing all the names of the Wayfarer parties that were involved in it, so they said Justin Baldoni by name, Jamie Heath by name, Steve Sarowitz by name, Jed Wallace by name, and both Melissa Nathan and Jen Abel by name in there, all through their article, then I would be asking, who are those 1 to 10 inclusive? Why are their names not there? And if they have not done that basic due diligence, if I was Wayfarer, I would be raising that. Now we have this information and we've started to fill some gaps. Now, I don't know how that would pan out. Because again, we will get, Wayfarer will respond to the motion for summary judgment, and then the New York Times will respond to that response. But I would be certainly pointing this out. Those are the two main things I would be pointing out is, one, actually is a court order saying that, for now, our ability to appeal is frozen, but we intend to appeal at the earliest opportunity, or we have no intention of appealing. And then I would be saying, well, they refer to obtain all the stuff they went through, which was obtained by a subpoena. Did they bother to check the subpoena? What subpoena did they review? Because this is a subpoena and it mentions absolutely nothing about Wayfarer at all. It also mentions nothing about Blake Lively in terms of the parties that the subpoena has been filed in the lawsuit, that the subpoena has been filed with. So, Van Zandt was not sexually harassed, was it? I would be asking questions like that. It probably still won't go too far, but it would certainly make the New York Times potentially a little bit uncomfortable. It might even cast a spotlight over their investigative journalism skills. It probably still wouldn't pierce the fair reporting privilege. But it's an argument that they can leverage where Wayfarer can say, well, hold on a minute. Actually, our complaint was not entirely meritorious because this is information we did not know about at the time. But this obviously raises some significant questions. That it may help. Okay, so I wanted to go through some of that and just share some of my thoughts and talk it through. And again, I stand by what I say. Unless Wayfarer come back with a hell of a response, I do think the New York Times will probably win their motion for their fees. That is not going to prop up Lively in any way, shape, or form. That is not going to make them more likely to lose their defense against Lively's claims. It also does not mean that they cannot still, appeal, because a decision on this may be kind of set aside and kind of held off until the point they do file a notice of appeal. If they file a notice of appeal, then it's possible that this might have to take a back seat for a little bit. But just kind of throwing out some thoughts in general, I do think they will lose, and that's kind of my opinion. But that's purely based on what the law says, and we've gone through that, and specifically what it says and how that applies to this case. And I hopefully now it makes a little bit more sense. And then that may be why Wayfarer didn't bother to oppose New York Times' request to enter final judgment. Because it's hard enough to take on these kind of corporations and win. It is incredibly hard. I think the New York Times has not been successfully sued in over 60 years. So the fact that Lyman, his reasoning was sound in law. Again, I'm only talking about the New York Times, not about Lively or Sloan. I don't like Leslie Sloan, but I don't think there was enough of a case there myself. I've talked about what I think of James Fatuska. I think there was some stuff from Leslie Sloan potentially that we've since found out since she's been dismissed, which Wayfarer could cite new evidence to. Ryan Reynolds, I think that was a huge mistake. I do. I think he should have been, if he's going to be dismissed at all, I think it should have been without prejudice, so they could have amended their complaint. Because the complaint in itself was not strong enough. It did not state a kind of a solid claim. We never really did get to the meat and bones of who were these statements, these defamatory statements that Ryan Reynolds made. Who were they made to? When? We've now seen them, and yes, he said them, but at the time, Wayfarer were not kind of clear, and they did not allege malice. In particularly, not significant, not strong enough for the purposes of a defamation claim. There was things we can all look at it, and we did look at it. We were like, "Oh yeah, that's definitely that sounds like malice." And there was many things I felt could have pointed to actual malice, but I think in terms of the actual complaint, it's Wayfarer's burden to state it clearly and show that it meets the legal threshold, and their complaint didn't do that, unfortunately. So I think they're going to win. New York Times are going to win their claim. But again, we've got Wayfarer's response is, when is it due? I think it's the 27th of February. It's around that time, give or take a few days. So we'll keep an eye on that. We'll come back to it at the time. I'm going to leave it there. Thanks, guys.